Well, Professor Knapp, it's 5 p.m. and I want to be mindful of your time. So should we just jump right in? And uh, tonight we have Professor Knapp here to help us out with how to write a case note. I know for a fact you'll find this incredibly useful. And we're very grateful to Professor Knapp for joining us, especially because I believe you're the faculty advisor for the Public Policy Journal.
I am.
So he's helping out I don't know if we're rivals then in that
Not
case,
a
but
rival.
all
Partner
right,
journal.
a partner journal. Love it. Well, with that note, I'll pass it over to you.
Well, thank you very much, Devin. I'm happy to be here tonight. I'm going to spend some time talking about writing the case note, but I don't want to do that in an abstract way. So what I did and what I typically do when I do this presentation is I decided to take a look at a relatively new Supreme Court case. So I will flash up here information about that case, which is called Austin versus Reagan National Advertising et al. And it was decided sometime last week. And like every other case, it tells two stories. The first one is a factual story, and the factual story is really pretty straightforward. This turned out to be a case about regulating signage, signs like billboards, in the city of Austin, Texas. And Austin had a regulation that distinguished between off-premises signs and on-premises signs. And I don't know a whole lot about billboards. I know nothing at all about billboard regulation. And I'd never understood or heard the distinction between off-premises signs and on-premises signs until I read this case. But it's fairly straightforward. An on-premises sign is one that is on the same premises as the thing that it's advertising. So if I start a pizza shop and I put up a sign on my property that advertises my pizza shop, that's an on-premises sign. If I rent space on a billboard advertising my pizza shop, that's an off-premises sign. And the main thing that Austin's regulations did that ended up disturbing the plaintiff in this case and giving rise to the lawsuit, Austin said, we are going to prohibit constructions of new off-premises signs. We'll grandfather in some signs, those that are there can stay, but we're not going to permit the construction of any new off-premises signs. Reagan National Advertising owned a bunch of billboards in the city of Austin. What they wanted to do was convert those billboards, which were old-fashioned analog billboards that you would just see some display on, to new digital billboards. And they wanted to digitize the billboards. They submitted an application to do so, and the city of Austin denied the application. And that really is the sum total of the set of facts that gave rise to this lawsuit. Procedurally, what happened once those permits were denied is Reagan Advertising filed suit in state court. And they alleged that forbidding the digitization of their signs or denying their application to do so, and not doing that with on-premises signs, treated them differently and violated the First Amendment's free speech clause. City of Austin says, well, here we are in Texas state court. Let's get ourselves over to federal court. They removed the case to federal court, and the United States District Court held that the regulation was facially content neutral. If we're just looking at the regulation, qua regulation, as opposed to the application of the regulation, it's content neutral. We're going to use an intermediate scrutiny standard to take a look at it. And they held that the regulation met that intermediate scrutiny standard. The Fifth Circuit reversed Austin had won below. Reagan appealed. Fifth Circuit reverses, and they hold in their opinion that there's very easy tests that we ought to be doing to take a look and see how it is we should approach analyzing this particular situation. If a government official has got to read the sign to know if it was an off-premises sign, then the regulation is not content neutral. And the reason the regulation isn't content neutral is because the government officials got to look at the content of the sign. And if you got to look at the content of the sign in order to figure out whether or not it applies, then that regulation is not content neutral and it's subject to strict scrutiny. And as those of you that have looked at con law know, most of the time something's subject to strict scrutiny gets a lot harder for it to be held constitutional. And that's the procedural story until we get to the Supreme Court. Well, at the Supreme Court, here's what happened. The Supreme Court ended up reversing the Fifth Circuit. And in an opinion for the court, Justice Sotomayor was joined by Chief Justice Roberts, Justice Breyer, Justice Kagan, and Justice Kavanaugh. Justice Breyer wrote a separate concurrence. Justice Alito concurred in part and dissented in part. Justice Thomas, joined by Justices Gorsuch and Barrett, ends up dissenting and saying, no, this is not a decision that should be reversed. The question that was presented for the Supreme Court was a fairly straightforward one. As the opinion written by Justice Sotomayor puts it, is the regulation subject to strict scrutiny under the court's precedents interpreting free speech clause? And the precedent that she was looking at on behalf of the court, the precedent that Justice Breyer takes up in his concurrence, and certainly one of the key points of precedent that Justice Thomas looks at in his dissent, is a 2015 case called Reed versus Town of Gilbert. Justice Sotomayor, in her opinion, says, well, look, we see Reed. Reed looked at a very different kind of set of restrictions. In fact, in Reed, the city of Gilbert had 23 different categories of signs that they were regulating. They gave the most favorable treatment to signs that they characterized as ideological signs. And the court there reasoned that regulation targeted at specific subject matter had to be content-based. And Justice Sotomayor says, look, we don't have that problem here. That is not the situation that's presented in this case. In this case, we have a regulation that is very, very different in the way it operates. Here's what she says. In this case, enforcing the city's challenge sign code provisions requires reading a billboard to determine whether it directs readers to the property on which it stands or to some other off-site location. Unlike the sign code at issue in Reed, the city's provisions at issue here do not single out any topic or subject matter for differential treatment. The on-off premises distinction is therefore similar to ordinary time, place, or manner restrictions, and that makes it subject to a much lesser scrutiny. The Fifth Circuit got it wrong. Justice Breyer, in his concurrence, says, well, I don't like Reed. I've never much liked Reed, but it is the law. And there's no evidence here, if we're going to apply Reed, that the city was trying to censor any particular view. So I'm going to concur in the result. Justice Alito, in his concurrence and dissent, has a somewhat different take. He says, the sign code provisions challenged here do not discriminate on the basis of the topic discussed or the idea or message expressed, according to the majority. But that categorical statement isn't completely true. The provisions defining on and off sign premises clearly discriminate on those grounds, at least as applied in some situations. And because I can't say that facially in every situation, this challenge doesn't revolve around content or message expressed, strict scrutiny should be applied at least in some of the circumstances that were presented. And Justice Thomas, in his dissent, has a completely different perspective altogether. Justice Thomas says, per Reed, it does not matter that Austin's code defines regulated speech by function or purpose, that is, advertising, directing passerby elsewhere. All that matters is that the regulation draws distinctions based on a sign's communicative content, which the off-premises restriction plainly does. Consequently, this set of regulations should be subject to strict scrutiny. Well, I read through the case. I thought, well, here's a whole area of law I'm largely unfamiliar with. If I had to write a case note about this case, how would I go about doing that? Well, the first thing you need to know, of course, is the structure of a case note. And the structure of a case note is fairly straightforward. It does ask you to analyze and consider a particular case. And you might say to yourself, I'm not sure I've ever written anything that really does that. My suggestion to you is you've written analysis of case law in situations where you are advocating for a particular point of view. Here you're going to be advocating for a particular conclusion, one that you get to choose. And that's what your case note overall is meant to do. And it does that with 5 different distinctive parts: an introduction, history of case law, case description, analysis, and conclusion. And those parts, we'll talk about each of them at least in passing, are fairly straightforward, particularly that first one, introduction. All that is doing is letting the reader know where it is you're going to be going. And the only way that people really get themselves in trouble in introductions is if they try to do too much or too little. And more often than not, people get very excited about writing the introduction and sometimes sort of slip into tabloid headline motifs. Supreme Court guts the rule in Reed, I think would be an overstatement of what happens. Kavanaugh is a secret liberal and joins Justice Sotomayor, I think would be misreading Justice Kavanaugh's position in this case and what it was the court was doing in that majority opinion. History. Well, none of these cases come to us without some kind of background in history, because all of them come as a result of individual litigants seeking some sort of redress in a lower court. And they always have some basis in law for doing that, particularly if the case makes it all the way up the chain to the United States Supreme Court. There's usually a lot of history. And if you go through City of Austin versus Reagan National Advertising of Austin, you see a wealth of legal history here. There's citations to constitutional provisions. There are any number of different cases cited by the different justices in their different opinions along the way. And of course, there's the history of the case itself, the denial of the application, the state suit, the removal to federal court, the federal district court decision, the Fifth Circuit decision. And that's all part of this case history, just like some of the case law underlying the justice's analysis in City of Austin, and in particular, the Reed case, which all of the justices cite in their opinion. You're going to find that you get a little bit of a head start on case history, because invariably the author of the majority opinion goes through the history of the individual case that is up for decision, and then sketches out thoughtfully, we hope, the case law that gave rise to this particular dispute on which this case is going to turn. And that's super helpful until, of course, if you have a dissent, as we do here, you turn to the dissent and you see that it's possible for case history to reflect two different points of view, because Justice Thomas's account, not of this particular case, but of the precedent that gives rise to the decision, is quite a bit different than Justice Sotomayor's. The other place that you find case history in the particular area, of course, might be in commentary, in a treatise. And there are plenty of constitutional law treatises that are out there. And in fact, there's a law review article that's cited, several law review articles that are cited by Justice Thomas. And I poked open one of them as I was getting ready for this presentation. And sure enough, in that law review article, there's a lengthy account of the history of the case that all of in case law that all of the justices are looking at, the Reed case, in the aftermath of that Supreme Court decision in 2015. So we seldom have trouble finding enough case history. The challenge in writing the case note is always, how much history do I need, and which history do I need? And we're going to talk about that, but this is supposed to be the section that gives the reader the necessary information first to understand this particular case. Where did it come from? What is the dispute? How did it get here? What were the decisions along the way? And second, understand the legal context in which it arises. The next piece of a case note is a case description. And that case description is pretty much what you would expect it to be. But I'm holding, I picked a relatively short Supreme Court decision, but it's still 25 pages long. And so the challenge when you're writing your own case description is what needs to be highlighted, what seems interesting, what seems controversial. Obviously, we're going to need to give an account of the essential factual and procedural stories that lead to this decision, but what are the parts of each of these opinions that I want to flag and highlight for the reader's attention so they can understand what it is I'm writing about. And you want that report on the case to be thoughtful. You want it to give adequate context, but you also know it's not going to be the central part of your case note, because the central part of the case note is going to be what follows next, analysis. And that, of course, is going to be probably the most challenging part of the case note to write. You've done plenty of legal analysis by the time you get to this stage of law school. And you know what kinds of questions that you end up asking in order to understand a particular kind of case. Here, you've got First Amendment issues. You've got Justice Sotomayor and Justice Thomas in disagreement about the limits of protection the First Amendment gives. You've got plenty of issues on that principle. Justice Sotomayor has said, well, look, we permit ordinary time, place, or manner restrictions, and that's really what's going on here. We've approved location-based differential for advertising in this country as being constitutionally sound for almost a century. Breyer's concurrence looks at this notion of principle in a somewhat different way. This is about Oliver Wendell Holmes Jr. and the marketplace of ideas. And the real question that we should always be asking ourselves in these cases is somehow ideas being driven from the marketplace by regulation. And Justice Thomas, unsurprisingly, has a very different point of view altogether. And he says, look, this is a covert attempt to allow content-based regulation, and it's attempting to resuscitate a principle in a case that we've largely abandoned, Hill versus Colorado. So there's plenty to write about and analyze if what you want to look at is principle. There's plenty to write about and analyze if what you want to write about is use of precedent. Justice Sotomayor, in her opinion, says, unlike Reed, the city's provisions at issue here don't single out a topic or subject matter for differential treatment. Justice Alito, in his concurrence and dissent, says, no, you're stretching our precedent. The difference between on and off premises signs clearly discriminate on the basis of the topic discussed or the message expressed. That distinction itself is based on the content of the sign. Consider a coffee shop sign in the window that advertises a new latte that's being sold on the premises. That's clearly an on-premise sign, versus the same sign in the same window that promotes vaccination at an adjacent pharmacy. That would be off premises. The regulations would distinguish between the messages of those signs. In that situation, they'd be content-based. And you're distorting and stretching the precedent that was laid out in Reed. And Justice Thomas says, no, Reed was all about bright lines. It held that a law is content-based on its face if it draws distinctions based on the message a speaker conveys. Some facial distinctions are going to be more subtle, and they're going to define regulated speech by function or purpose. That's what's happening here. So if you want to analyze the use of precedent, you've got plenty of competing points of view. You may look at this and say, it's largely a matter of practicalities. That's Justice Alito's position. He said, if you look at these different signs, we've got a record that's filled with different pictures, you can see that a number of them are standing on vacant property. If they're standing on vacant property, they must obviously be off-premise signs because there's no premises there. And there's consequently no need to read the sign. So the Fifth Circuit got it wrong, but we need to be far more attuned to the practical realities of this particular case and the differences among these signs. And from a policy standpoint, Justice Breyer in his concurrence says, Reed is binding precedent. I don't like it, but it's because it's wrong, but we're stuck with it. And what we really should be thinking about is the fact that the First Amendment, as he puts it, is not the tax code. Its purposes are better served when judge-made categories are treated not as bright line rules, but as rules of thumb. Strict formalism does disservice to the First Amendment principles meant to be protected. This should be about balancing. Justice Thomas says no. In Reed, we concluded that a clear and firm rule governing content neutrality is an essential means of protecting the freedom of speech, even if laws that might seem entirely reasonable will sometimes be struck down because of their content-based nature. That's what this is all about, and that is the policy that we should be following. We need a bright line rule. So there's plenty here to analyze. The hard part, of course, is going to be doing the analysis and figuring out what the analysis is about. And to do that, you're going to need to have a firm grasp of your conclusion. And I think for many of us, this is always the most intimidating thing about writing a case note or opining on any particular case. Who am I to second guess or analyze a particular opinion authored by a Supreme Court justice? Well, that's your mission in a case note. And after you've read the case and after you've read the history, chances are pretty good, opinionated people that you are, that you're going to have a take that at least one of these justices is right and one of them is wrong, or perhaps you're going to have opinion that they all are off the mark in some particular way. You may decide this is a case that gives life to the Reed precedent in a sensible context. You may decide, no, this is a case that undermines the precedent of Reed. But you need to make a choice. Because the one place that I think people most often get case note wrong is failing to pick a strong conclusion. You don't need to excoriate the case or any particular opinion, but you need to do something more than say, well, courts decide cases, and this is another example of that happening. You need a conclusion that really speaks to some of these issues, because if you don't have that conclusion, it's going to be really hard to do any sort of meaningful analysis, whether you decide to focus on principle, decide to focus on policy, or decide to focus on precedent. Well, okay. If we've got a basic understanding of the parts of case note, what happens next? How do I go about writing a case note? Well, I will confess something to you. Certainly when I was a law student, but I would say even after that, if you told me, look, here's a Supreme Court case, read it and write a case note about it. And here are the 5 parts of a case note. I would have read through the case and I would have started writing the case note with the introduction, gone ahead and written a history, probably would have needed to do some additional legal research there. And I'll confess, I probably would have ended up doing a lot of research, given that this is an area I don't know a whole lot about. I would have written a case description, and then I would have started analyzing the case along some sort of line. And eventually, after doing that analysis, I would say, okay, I can come to a conclusion. I would have written the conclusion. I am here to tell you that I would have done that, and this is the confessional part, because it would have seemed to me like the quickest and easiest way to write a case note. I'll start at the beginning, I'll write straightforward to the end. And the self-awareness is in an effort to do this in the easiest possible way. I would have ended up writing that case note in what has to be close to the dumbest possible way, because that is not a good way to approach writing a case note. How should we write case note? Let go of that order, first of all. And if you're going to write a case note, the obvious critical first step is to read the case. And give yourself some time to do that. Give yourself some time to jot, as I have here, and I'm old school enough that it happens with a pencil and a highlighter, things I don't understand, or things that seem out of place to me, or things that seem surprising to me. I highlight the parts that seem important. I write in notes. I read the case. And that's obviously the first thing you need to do if you're going to write a case note. And the second thing you need to do, once you've finished it, that first thing is to go back and read it again. And this was always the hard part for me. Well, I just read it. And it's the hard part for me to do now when I'm working with a case. Okay, I've read the case. I've been reading cases now for years and years and years and years and years. I've gotten pretty good at it. Do I really have to read it again? And my answer to myself is, yeah. If you want to understand what's going on in this case, you really do need to read it again. And part of the reason is, once I finished reading Justice Thomas's dissent, once I finished reading Justice Thomas's critique of the way Justice Sotomayor has made use of the Reed decision, when I go back and I read that opinion for the court that she's written, I'm going to be looking at it from a somewhat different point of view. And by the time I get to the end and I again encounter, for example, Justice Alito's concurrence and dissent, and then Justice Thomas's dissent, having reread that opinion for the court, those dissents are going to look different to me as well. So read the case and read it carefully, and feel free to do some highlighting and feel free to do some note taking. But once you've done that, recognize that the next thing you really ought to do is read it again. And from there, and this was the part that was just impossible for me to do when I started writing about cases, write out a case description. And there are two reasons to do that. And the first is this: the discipline of writing about something ensures that our understanding of the thing that we're writing about is going to get deeper. It's going to improve. If I tell myself, okay, I've read this twice, I need to write a description of what this case is about and what's happening in its various parts, I'm going to understand that case a lot better, even after 2 careful readings, by writing that case description. But here's the other thing, and it's one of the most important things that I have learned about writing. It's going to get me started. And I'm going to get started with writing this case description, and I'm going to feel uncomfortable about it because I know the case description isn't going to be very good. And I know that because I really haven't done much other than read the case twice, and I don't really know much about this area of constitutional law, and I certainly don't know much about the regulation of billboards. So it's not going to be a very good start. Well, the best written advice about writing that I've ever read, I mean, I like Brian Garner, I read all the other folks too. It's actually an author named Annie Lamott, and she wrote a book called Bird by Bird. And it really is a book about writing fiction, or that's the intended audience, but it's actually a book about writing. And one of the things that she says, and I apologize for the language, but she says is you've got to get used to writing shitty first drafts. Because if you're going to write, your first drafts aren't going to be very good, but there's never going to be a second draft until there's a first draft. So get started and accustom yourself to that kind of sinking feeling, this draft isn't very good. And from there, having written out an initial draft of case description, write some history. Because you're going to look at that case description and say, all right, in order to understand this, what do I need to understand first about this particular case and where it came from? And what do I need to understand the analysis that's going on in this case? And then, strangely enough, having written that, I'm going to ask and suggest that the next thing to do is to write a conclusion. If you do this, if you discipline yourself to say, all right, I'm going to write a description of the case, I'm going to write a preliminary analysis, a preliminary discussion of the history so I know where it comes from, and then I'm going to write the first draft of my conclusion, you've armed yourself and prepared some of the most important pieces of your case note. And they're the pieces you need to work productively on the rest of the case and the rest of the case note. And you've only read one case, the case you're analyzing. Having done that, you have in hand a pretty good working understanding of this case, some understanding of where it came from, even though you haven't read much yet. And most important, a preliminary sense of where you're going to go with all of this. What do I think about this case? What strikes me as important? What strikes me as departure from existing law? What just strikes me as consistent with Reed? What strikes me as at odds with Reed? Which of these opinions that I'm writing seems to make the most sense to me, or do any of them make sense? Perhaps the Supreme Court missed the boat on this one. Whatever it is, you've got a preliminary conclusion. And it's only a first draft, and it's subject to all the foibles of any first draft. But once you have a conclusion in mind, it's far easier to figure out where you're going next. With that conclusion in mind, go back and look at your case description again. Chances are it's not doing everything you want it to do to bolster that conclusion. And that's when you begin your analysis. I'm going to write my analysis. I recognize that may send me to the library. You know what? I'm writing that this is a departure from Reed. I'd better go back and I'd better read Reed. I'm not ever going to understand what's going on until I actually look at that case for myself. I'm going to go read that. And reading that case, perhaps you're going to say, you know, this Hill versus Colorado case that Justice Thomas is concerned about, I think I'm going to read that case as well. But you're reading with a purpose. You're reading with a purpose in mind. I've got a preliminary conclusion. I think it's the one that I'm going to be writing about, but I'm willing to vary it and change it based on my analysis and my reading. But now I'm reading with a purpose. Now I'm researching with a purpose. And I'm not doing what I would have done as a law student, what I tended to do when I was first in practice and had to write about a case. I'm not just reading cases that I find the names of in the particular opinion. I'm not wandering through all of jurisprudence. I'm moving forward with a purpose in mind. And having that purpose in mind is absolutely critical. I think of all the times that I decided I was going to write about a case or write about the law. And sometimes it was in service of a summary judgment motion. Sometimes it was in service of writing a memorandum that people were going to use to understand a case. All the times I spent in the library reading cases thinking, okay, I'm getting smarter. Yeah, maybe I was getting smarter, but I was getting smarter in a really inefficient way because I hadn't done the basic work necessary to think through about where I was going. What's my conclusion going to be? And as a consequence, I was reading cases, and I will confess in the days before doing everything online, sometimes what I was doing was copying cases and feeling that that was almost the same. Now, you know, of course, I just print out the cases. I've got a big stack of cases. Look how smart I am. I've got just a huge stack of cases here that I've printed out and kind of looked at, but I don't know why I'm doing it because I don't know where I'm going. With a conclusion that you've started to understand and think about, that additional research that you're doing is done with the purpose of supporting that conclusion, of honing that analysis, and you are improving the work that you're doing as you go along, and ideally, you're redrafting as you go along. You know, I understand what's going on in this case, but maybe I'd better take a look at what the Fifth Circuit said and read that preliminary opinion because none of these Supreme Court justices seemed to think that they were doing it the right way. What did they do that was so off the mark, both for the dissent and for the majority? Maybe the Supreme Court didn't like it because it doesn't fit with where they want to go, but maybe it sketches out something that's really important to know. Maybe I should take a look at that district court decision. But I'm reading the history and reading these additional cases with the purpose of improving my, oh my gosh, it's like I have a draft here. I have a draft of my case description that I've already rewritten once. I've got a conclusion that I'm writing analysis to support, and I'm writing history that is meant to give better, thoughtful context to the case note that is emerging from this work in a way that is, with any luck, a little bit more organic and a little bit more purposeful than what I would have done when I first started these kinds of exercises. And when I get all the way through all of this, that's when I write the introduction. It used to be that, I would hear people say, well, this introduction does a really good job of summarizing what follows. How did you do that? Well, I have a great trick for doing that now. I write them last. They're so much easier to write when you know what it is you're introducing. There's no reason to let that structure of the case law itself dictate the order of your drafting. Find something that works for you, but I've got to say something like this works pretty well. And the idea that you're already up and writing after you've read only one case, I think is a really powerful way to avoid one of the things that happens the most often to people who are engaged in this exercise for this competition. I put in a lot of time. I spent a lot of time reading cases. I spent a lot of time, if I'm here on campus, in the library. And man, oh man, did I do a lot of work. But I just ran out of time to write the case note itself. Don't let that happen to you. If you're going to put in the work to understand the case and to engage in this competition, make sure you produce a draft that you can turn in. Because the two biggest pitfalls to avoid in this exercise are these. The first is, I don't know where to begin. I confess, when I started reading this decision, and by the time I'd gotten to the end, I thought, I'm not really sure what my conclusion is about this. I'm not really sure where I would begin. And the temptation that I had, certainly as a law student and as a new lawyer, was always the same. I need to understand more. I'm going to go back, and before I do anything else, I'm going to read that Fifth Circuit opinion. I'm going to read that district court opinion. I'm going to look at Reed. I'm going to read the Reed decision, and then I'm going to look at the cases that Reed relies on, and I'm going to read those as well. I made my way through a lot of cases, but I didn't start writing. If you start your writing early and use it to guide your process of research, you're also going to find out one of the things that I think is both a joy and frustration, the practice of law and writing in the practice of law. You're going to have a first draft well before it's time to turn it in. It's not going to be very good, but your second draft, and you're going to have time to write, to edit, to produce that second draft, it's going to be a lot better. And your third draft is going to be better still. From time to time, a lot of the work I do here is work done in the clinic. From time to time, I end up handling a case that a student is no longer handling, typically because they've graduated and moved on and they're doing something like studying for the bar exam. And I had an opportunity to do that recently. I wrote, it was a short Court of Appeals brief, but I wrote the brief and I thought, this is pretty good. I know this case. I supervised the student who worked on it. I helped work with the student when they wrote the letter brief that they submitted to the administrative agency. I know the law in this area. I'm very familiar with the law in this area, far more familiar than I am with the law that guides the case City versus Austin. And I wrote that first draft and I thought, that's pretty good. And I set it aside. And I came back a couple days later and I went, it looked better 2 days ago than it does now. And so I put some serious time and attention into that second draft, and it was markedly improved. Went back and looked at some things in the record that I hadn't bothered to look at quite as carefully as I probably should have, added some quotes from some of the transcript, took a second look at some of the precedent, and set it aside and came back to it a few days later. And that second draft that had seemed like a beacon of perfection. I really ought to make this widely available so people can see what a perfect brief looks like. It still needed some work, and that third draft was better still. I've been doing this a long time. I love getting a chance to produce legal writing again in that setting. But it turns out even after you've been doing this a long time, your third drafts are still a lot better than your second drafts. And man, oh man, are those second drafts a lot better than those first drafts. Give yourself the opportunity to start writing early on. Begin before you know exactly what the finished product is going to look like. And you're going to have an opportunity to edit and improve that you're going to lose if you fall into that trap of thinking, I don't know where to begin, so I'm just going to start reading a lot of cases, and I'm going to save the writing for the end. Second thing that I think happens to people is you write a lot about the case and the history of the case, but not as much about what it means. And that analysis, that is the heart and soul of the case note. That is what the rest of the case note, the case description and the history, that's got to be good. It's got to be solid. But the analysis is where you really are displaying your thinking and bringing yourself to this process. And that can only happen if you're willing to take the time to start writing about what you think and not just about what the case says. And the only way that you can do that is if you've got a conclusion in hand. So grab hold of one early. Feel free to revise it as you go along, but grab hold of it early because that's going to allow you to do the kind of analysis that's going to really set that case note apart from something that merely summarizes. Well, that's my advice about writing case notes. And the hope is that it gets you writing sooner, saves you some time on extraneous research by focusing your research, and most important, gives you a chance to finish not just a first draft, but ideally chance to edit and refine that first draft and then polish a second draft so that you've really ended up using the time to do a fair amount of writing and a directed amount of research and study. And I'm happy to answer questions. And if there aren't any, I'm happy to let you go too.
I have a question, and this might just be ignorance, but what happens to these case notes? Like, how are they used either in the law school setting or in like the professional setting? And I'm sorry about my dog.
Well, I'm going to let Devin answer that, but I'll tell you how I use them. A lot of times I'm coming to an area of law where I recognize there's a new case that is significant. Sometimes I'll take a look at the case, and if I pulled it up on Westlaw, which would not be unusual, and I look at citing references and I see a case note, the very next thing I do is I read the case note, because I'm going to look at that and say, if this is a good case note, it's going to significantly improve my understanding of why this case is significant and what it does and what it doesn't do, because someone else has done that work. So as a practitioner, if there's a case note in an area where I'm using a case to write a brief, for example, that's gold to me. And if I'm writing about the case myself, or if I'm writing about a case that relies on that case for purposes of putting together an article, I'm going to be sure to take a look at it, because a discussion of history is going to be very useful to me in understanding what it is that led to this issue that I'm writing about. Devin, pieces to add?
Yeah, I mean, for law review's purpose, I think we'd be happy to be enlightened by any new ideas or insight about the case. But we use it to sort of test your writing skills and your citation skills, because a big part of being an associate is those two things: writing your own long paper, and then correcting citations and things like that. But I think if you follow Professor Knapp's advice here to the T, you'll have a good chance at being the one case note that would get selected to move forward and be published. So you would turn your case note that's 16 to 20 pages into the full length long paper. So that's a little carrot to follow Professor Knapp's advice.
Thank you. I appreciate that.
I saw one question in the chat. Any tips to be successful at this write-on process? I think Professor Knapp's advice on read the case right away is helpful. So it's a 2-week stretch that you have to write the case note. And to be honest, I did not follow Professor Knapp's advice well enough. I did not start writing anything until after the first week, because it just took me a long time to pull something out of the case that I really wanted to hone in on or thought I could add to. So I think that's part of it. And then, so you'll have a closed universe. So the research will have been done for you. So take a look through, and it'll be a lot. There'll be a lot of different sources there, cases and statutes and law review articles. So also, think about what your conclusion would be, like Professor Knapp said, but then see where the sources kind of take you also. So there's like an artificial cap on how far you can go. You won't have to print off too big a stack of cases, but you might find that your idea is also covered in the sources, which would be great, which is how it happened for me last year. So the thing I finally realized I could talk about, I had plenty of material to write the full case note with. Yeah, John, go ahead.
Yeah, just out of curiosity, when you pick the state supreme case that we're going to be looking at writing this case note on, since we presumably have most of the same classes together, are you going to be looking at something kind of within something we've taken, like towards your basic crim, or is it going to be something completely out of left field that we're going to have to really wrap our head around?
Without giving too much away, I believe this will be a class that you've had before. So like we did eliminate some things that maybe like 2L or 1L blended students haven't taken yet. So it'll be something you're at least somewhat familiar with.
Excellent, thank you.
Yeah, Sydney, go ahead.
So just for clarification, at the beginning you were saying like the list of issues. So what we're kind of doing is writing out the issues that we see in the case and then picking one to hone in on as like our decision that we're writing about, right?
Yeah, yeah. And in the handbook too that you'll get once this all comes out, there's some helpful guiding questions in there, and they kind of reflect what Professor Knapp was saying. And I'm thinking about what I wrote last year, and it ended up looking kind of like a concurrence. Like I agreed with how the court ended up ruling, but I was like, but I don't quite agree with how they got there. So if you think about it in that way too, that might be a helpful framework. I don't know, Professor Knapp, anything else to add there?
I think that's a really nice analogy, the concurrence. Yeah, and some of you may end up writing dissents.
Yeah, Angel, go ahead.
Oh yeah, I was kind of thinking along the same lines as the last question, because Professor Knapp spoke about principle, policy, and precedent. So would you think it would be better to hone in on one, or can you talk about more than one? What's your advice there?
I think probably best to focus on one. 16 to 20 pages like feels like a lot at first, but ideally you'll hit a point where it's just like you have too many ideas and arguments that you're pushing into just one of those topics, and you'll probably hopefully find yourself having to scale back and revise down. So I think one of those avenues would be plenty for you, and more direct.
Thanks, Devin.
Any other questions for Professor Knapp? I think we have 3 minutes left with him. No. All right, seeing none. Well, I hope you all really enjoyed this. It will be up on YouTube, so you can refer back to it. Professor Knapp, thank you, truly. Really appreciate you being here tonight, taking some time out of your evening to provide us this wonderful advice.
Happy to do it. Thank you so much, Tim.
Mhm.
Good luck,
Thank you.
everyone.
Thank you.
Thank you.